Hey everyone, and welcome to the bonus video for week 12 of our admin law course. For this video, I've made a flowchart to guide you through administrative law issues. Honestly, the flowchart is so useful that it's almost cheating. But it will only make sense if you've actually done the work from week to week throughout the term. If we come to a bit of the flowchart that's absolute gobbledygook to you, that's a sign that you need to go back into the substantive materials for the course and revise that part of the material. The idea of the flowchart is pretty simple, really. We start at the top and consider each question until we eventually find out what sort of application we can make and what sort of remedies we might obtain. Why don't you follow along while I walk you through the flowchart? The very first thing we need to consider is whether there's a decision. If there isn't a decision, then there's probably not much that administrative law can do to help. So we ask whether there is an actual decision, whether there is a failure to make a decision within a reasonable time, and whether there is conduct related to the making of a decision. Remembering that in this context, conduct refers to actions which are final, operative, or determinative, and not actions which are mere stepping stones towards the making of a decision. If we don't have a decision, a failure to make a decision, or conduct related to the making of a decision, well then we don't have the basis for an application in administrative law. If we do, however, next we have to ask whether the decision is a decision of an administrative character. We do this essentially by elimination. If a decision is a prerogative decision, then it's not subject to administrative law. If it's a legislative decision in the nature of rulemaking, then it's not a decision of an administrative nature. Remember that rulemaking establishes a rule of general application, whereas decision-making applies those rules to a specific instance. Third, if it's a decision of a judicial nature, then it's not a decision of an administrative nature. These can be hard to tell apart, but we can look for indicators. If the decision resolves questions of fact and law in order to render a judgment, it's more likely to be a judicial decision. If the decision declares pre-existing rights rather than creating new rights, then it's more likely to be a judicial decision. Finally, if the decision maker can just go ahead and enforce the decision without obtaining an order from the court, it's more likely to be a judicial decision. Now, if none of those apply, if it's not a prerogative decision, not rulemaking, and not a judicial decision, then we have a decision of an administrative character. We then need to ask whether that decision is made under an enactment. This is the university cases. So first we ask whether the decision is expressly required or authorised by the enactment. If it is, then it's probably a decision made under an enactment. Second, we ask whether the decision, which is expressly required or authorised by the enactment, has the effect itself of conferring, altering, or otherwise affecting legal rights and obligations. If the answer to that is yes, well then all of a sudden we have a decision of an administrative character made under an enactment. For a moment though, let's pretend the decision was no. Let's say we have a decision of an administrative nature not made under an enactment. Is there anything we can do to have such a decision reviewed? Well, maybe. In that case, the first thing we would do would be to look in any relevant legislation for a privative clause. A privative clause might remove our capacity to seek review of the decision. Let's say there's no privative clause though. We can't seek a statement of reasons for this decision because it's not a decision made under the ADJR Act. What we can do, however, is to make a Freedom of Information request to obtain the departmental files related to our decision. Remember, you can use a Haradine list to identify the relevant file. Once you get that information under Freedom of Information, you can examine it to see whether there is a legal error in the making of the decision. If you find a legal error and it's a jurisdictional error of law, well then you can most likely ask the court to review the decision, even if there's a privative clause. If you do seek the court's involvement, then in this situation you'll be seeking either a prerogative writ or in the Commonwealth a constitutional writ. These are the old school writs of certiorari, which bring a matter before the court mandamus, which tells someone to do their duty, prohibition, which stops certain conduct from occurring, habeas corpus, which brings the body of a person before the court in order to challenge their detention, and injunction or declaration, the equitable remedies that force people to do things, force people to stop doing things, or declare the rights of the parties. So if you have a decision of an administrative character not made under an enactment, that's the process you can undertake. Okay, let's step back and look at how it works if we do have a decision of an administrative nature made under an enactment. Again, we ask if a privative clause applies or if there's an ADJR Act exemption. If there is, then again, we'll be looking for a jurisdictional error of law and seeking a prerogative or constitutional writ from the court. But if there is no privative clause, well, suddenly we have a reviewable decision. We have a decision of an administrative character made under an enactment, and there's no countervailing enactment to say the decision can't be reviewed. So it's on for one and all. Our first step is going to be requesting a statement of reasons. So if we haven't already seen all of the materials relied on by the decision maker, and if we haven't already been given an account of their reasoning, we will ask for that and get them on the record. Hopefully that'll get us all the information we need, but if it doesn't, then our next step is to work through the freedom of information process in the way that I've just described. Once we've done this, we ought to be able to tell whether our problem with the decision is a problem with the merits of the decision, a problem with the legality of the decision, or both. If the problem is the merits, then we look at the enactment under which the decision was made. We're looking specifically to find out whether there is a provision in the enactment which grants jurisdiction to the Administrative Appeals Tribunal to review the specific type of decision that we're interested in. If there is, well, then we apply to the Administrative Appeals Tribunal and we follow the AAT's processes, and in the end, the AAT can affirm the decision under review, they can amend the decision, they can set it aside and completely remake the decision, or they can set it aside and send it back to the department to have another go. If, however, the enactment does not grant jurisdiction to the AAT, and our complaint is with the merits of the decision, then our best remaining option is to apply to the Ombudsman to review the decision. If the Ombudsman reviews the decision, they will report back to us and to the department, and if the Ombudsman makes a recommendation in our favour, there's a very good chance the department will reconsider. So those are our methods if there's a problem with the merits of the decision. What if our objection is to the lawfulness of the decision? Well, in that case, we're off to the court and we're seeking judicial review of the decision according to the criteria set out in Section 5 of the ADJR Act. We start by asking whether our client received procedural fairness. To do this, we start by asking whether the decision affected our client's rights, interests, and legitimate expectations. If it didn't, then they probably have no chance of successfully contesting the decision. If it did, however, we consider whether the decision maker was actually biased or whether there was apprehended bias, by which we mean that a fair-minded lay observer might reasonably apprehend that the decision maker might not bring an open mind to the decision. If there is bias, we challenge the decision on that ground. Next, we turn to the hearing rule of natural justice, and we ask whether the applicant was shown or told about the material that the decision maker relied on when making their decision, whether they had a reasonable opportunity to consider that material, and whether they had a reasonable opportunity to respond to those materials. If our client did not, well, then we challenge the decision on that ground. Either of those breaches, a breach of the bias rule or a breach of the hearing rule, amounts to a breach of the rules of natural justice. If there's no breach of the rule of natural justice, then we move on to the narrow ultra vires grounds for review. We ask whether the decision was authorised by the enactment under which it was made, whether all of the procedures were followed, if procedures were required in order to bring the power into existence, and whether the person who made the decision was properly authorised to do so. If any of those requirements don't line up, then we can challenge the decision by making the argument that the decision should not have been made at all. Next, we start to consider the grounds for review which focus on the way the decision was made, rather than focusing on the question of whether the decision should have been made at all. We ask whether there was an error of law in the making of the decision. We think about the evidence considered by the decision maker. Did they take into account irrelevant evidence? Did they fail to consider relevant evidence? Did they proceed on the basis that a particular fact existed even though there was no evidence of the existence of that fact? Any of these things would be a basis to challenge the decision. If the evidence was okay, we can then ask whether the decision was made for an improper purpose. In this context, an improper purpose means any purpose other than the purpose for which the power was granted. If the decision was made for an improper purpose, well, it can be challenged. If not, we go on to consider discretionary decisions. Remember, these are decisions which involve the decision maker exercising some level of personal judgment or giving things personal consideration. If a discretionary decision is made in bad faith, then the decision can be challenged. However, bad faith is a pretty serious allegation of personal fault by the decision maker. If we're making that allegation, we will usually have to allege the absence of honesty. This is going to have to be clearly alleged and clearly proved. Bad faith is distinct from mere poor decision making, and successfully proving it is both rare and extreme. You probably won't see a successful bad faith allegation during your career. If there's a discretionary decision but no bad faith, we ask whether the decision was made under the direction of some other person, usually a more senior person. We ask whether the discretionary decision was made simply by applying a policy without stopping to consider the individual circumstances of individual cases. And if either of these has happened, well then, again, we can challenge the decision. Next, we ask whether the decision was Wednesbury unreasonable. In other words, was it so unreasonable that no reasonable decision maker could have made the decision? Again though, Wednesbury unreasonableness is pretty rare. The courts won't allow it to be a sneaky way to obtain merits review in the court. Last of all, we ask if the decision was uncertain. In other words, was the decision expressed in a way that either made the decision itself ambiguous or meaningless, or did it perhaps have conditions attached that made the decision meaningless or ambiguous? If any of those conditions applies from natural justice onwards, then you can apply to the court for judicial review. Because the court does not undertake merits review, it won't usually remake the decision. It can affirm the decision, quash the decision, remit the decision back to the department to have another go. It can make a declaration expressing the rights of the parties, and we can be pretty confident that the relevant department would take those declarations seriously. Last of all, remember that a decision of the Administrative Appeals Tribunal can be appealed to the Federal Court, but only on a question of law. You can't appeal merits review to the Federal Court. The decisions of the court, however, can be appealed in the normal way. Now, that flowchart is lacking in detail. It's obviously not enough on its own. But if you've studied the administrative law that I've taught you in this course, you should be able to use this flowchart to at least begin to tackle most administrative law problems. Let me know how you go.